Hi, I'm Peter from Team Right Vows. Let's discuss on grounds of a labor ban in UAE. A labor ban may be imposed if the employee illegally terminated the employment contract or did not observe the provisions of the UAE labor law. For example, not respecting the notice period mentioned in his non-limited contract or terminating his limited contract before the end of its duration. He committed any of the violations listed in Article 120 of the UAE labor law. Worked with another company without obtaining a work permit. To stayed in the UAE after the termination of his employment contract for any reason for more than 2 months without legal justification.
Additionally, a labor ban is imposed on new non-skilled labor who did not complete 6 months of service with their respective employers. A labor ban is not limited to people having employment residence visa, but it also applies on any person who is issued a labor permit, a labor card, or a labor contract if he or she commits any violations, which entail the imposition of a labor ban. This means a labor ban may be issued against a working student under the visa sponsorship of his father or university, or a working woman under the sponsorship of her husband. Ban applications require an investigation from a legal researcher in Ministry of Human Resources and Emiratization who would invite both parties, the employer and employee, take their statements, judge the seriousness of the request, and decide whether to accept it or not. A person can check if he has a labor ban by calling the ministry hotline at 860, which is available 24/7. The employee can contest to the labor ban by submitting a grievance to Ministry of Human Resources and Emiratization. If you like the video, follow Right Vows page on LinkedIn or YouTube for more updates.